Пані Ірина, добрий день. Ви нас чуєте, бачите?
Irina, good afternoon. Can you see and hear us? Yes, I can. So welcome at the second stage of the selection to the High Qualifications Commission of Judges of Ukraine at the interview, and the interview is held by all members of the selection commission. These are Robert Brookhuizen, Ivan Mishchenko, Ted Zazhachny, Sergei Verlanov, Yevhen Mesentsev, and Steven Markman. The rapporteurs at your interview are me and my colleague Robert Brookhuizen. If for some reason, Irina, our interview is interrupted as a result of power outage or air alarm or any other technical issues, we will definitely reach you on some other day and some other time. Clear.
Пані Ірина,
So, Irina,
прохання відповідати коротко.
the request is that you provide concise and quick answers, and the member of the commission asking the question can actually limit the duration of your answer. Before the beginning of the interview, the commission will give you an opportunity to present yourself, to tell about your motivation, about your ideas, about your views, why you have decided to apply for this position. The floor is yours. You're welcome. Thank you. Well, let me introduce myself. I'm Iryna Davydovych. I'm 49 years old. I'm married. I don't have any children. I've got higher legal education. I'm associate professor in law, and I'm the PhD in law. After I graduated from postgraduate studies department in 1998, and up till now I have been working as a lecturer. Now I'm associate professor of the Department of Criminal Legal Policy and Criminal Law in Taras Shevchenko University. What about the teaching skills that have something to do with the work of the judiciary? These are development and teaching of the course related to the problems of applying means of legal and criminal procedure, in particular appointment of punishment. And as far as my current field of interest is concerned, that is all about judicial discretion and the limit of different factors influence on the judicial discretion. That's what I have to do with the judiciary. Also, I had probation in local courts twice in Kyiv, in trial courts. This is where I had to deal with the judiciary, and sometimes on my own, sometimes together with my colleagues, I worked at the development of the draft resolutions of the plenum of the Supreme Court of Ukraine, which still is the source that ensures unity of the legal practice. That is all I have to do with the legal system, or the judiciary, I mean. And my motivation is rather personal. First of all, I would like to try my hand in changing my field of activity and go forward. About 5 years ago, I realized that I have enough skills to really be teaching at Shevchenko University. And then, well, probably you could just stop at this and you could just work with whatever you have, and you can. But I would like to do something else and also to make an achievement in that. That is my motivation. The other point of my motivation is that I would like to achieve justice in appointment of judicial candidates and in their qualification assessment. Maybe we will still get back to this issue, but my experience of communication with the HQCJ was not a success. And the third issue is that I would like to convey the message to my students that if you don't have any contacts, any relationship, if you just have knowledge and expertise and skills and abilities, you can actually reach the top level, the top positions in our society. And with your permission, I would also like to tell you about the positive and negative features for you to get a clear picture of me. Concerning positive traits of character, first of all, I finished my school, which was the school with intensive studies of physics and mathematics, which means that I've got analytical skills and I can work quickly and absorb and master quite a lot of information. And it's not possible to influence me. I'm not subject to influence at all. This is about my positive sides. As far as negative sides are concerned, I don't have the skills of working in a team, and I have some grounds that this is going to be difficult for me to work in a team. Why? Because I don't trust people, and I don't shift the burden of responsibility on other people. And I understand that if the inspector of the HQCJ has prepared some material, I have to trust him or her. It will be difficult for me to trust. I always relied on the principle that if you want to do something good, work on your own. And it's very difficult to stop me. So, as far as the working in the team is concerned, at least I haven't tried my hand on this. But I think that it will be so. And sometimes I'm not very much reserved, and my judgments could be too categorical. I'm not sure that this is the best conduct while you're working with people, but that's what my disadvantages are. Well, thank you for your frankness, for your openness and honesty, Irina. Not that many candidates focus immediately on their negative traits. At least not a single candidate did this before you. But let's start our interview process. I was particularly focusing on your motivation letter and your ideas set out in the answer to paragraph 8 related to the vision of the judiciary, future judiciary of Ukraine. You suggest that judges are appointed, trial court judges are appointed, or rather, let me rephrase this. You suggest that they are elected by the community where they live. And also you suggest that they are elected for a certain period of time and that there is a mechanism of pre-scheduled withdrawal of those judges. At the same time, the Venice Commission has many a time in its opinions drawn a conclusion, and it calls this the probation period. Well, it criticizes it, and let me quote, "The above criticism lies in the fact that this probation period can actually limit the impartiality and independence of the judge, because the judge may pass some resolutions and opinions just for the sake of securing their future permanent appointment." So, to tell it in brief, if judges are appointed for a probation period, he or she will think not how to judge impartially and objectively, but about how to pass the decisions that will help him or her stay in the position after the end of the probation period. As far as I understand, you do not agree with the Venice Commission, or what? Well, okay, let me answer. First of all, the question was more about what are the measures through which we could restore trust in the judiciary. I don't think that the option I suggest is the best one and the only one, but I am talking here only about trial court judges. And after all the procedures that we now have, like the selection exam, training at the National School of Judges, qualification exam, and then getting into the backlist, and the competition announced by the HQCJ that presupposes the selection of the candidate who has a better score. So at this stage, I suggest that in case a competition is announced, people living in a certain territory for which the trial court's jurisdiction is valid, well, they could be elected there. This is not the best option, but I think that this is one of the mechanisms that could restore trust in the judiciary. That's it. Okay. But your ideas are related not just to trial court judges, but One more idea of yours is that you have to reduce financial remuneration for the judges of the Supreme Court. Yes, I can explain it perfectly well. I don't want to offend you, Ivan. Well, the Supreme Court is not paying to me anything like right now, so you're not offending me. The judges, well, we have 200 judges of the Supreme Court. 178, if I'm not mistaken, yes, but according to the law, it's up to 200. The cases considered by the Supreme Court, if we take, for example, well, any cassation cases or any other criminal cases, including the ones related to offenses and to non-grave crimes. Also, if we speak about civil cassation court within the Supreme Court, well, there is no limitation as far as the value of the claim is concerned. So it means that the judges of this court just do cassation, revision of all decisions. I don't think that is expedient. There is a great chamber, the Great Chamber of the Supreme Court, and it considers the issue of interpretation of the issue of penetration into the storage facility. And the case is that something has been stolen from the neighboring yard. Let me not analyze the conclusions that have been made, because the Code of Judicial Ethics actually prohibits to do this. I don't think that this is right. If judges really consider cases of top level, well, in criminal procedures, this could be grave and particularly grave crimes. In civil ones, it could be limited to some claim value or cost. This would be good. But if they are considering any cases, I don't think that their remuneration is justified, and the number of judges is not justified. If I'm not mistaken, the salary of members of the High Qualification Commission of Judges of Ukraine is directly linked in terms of the calculation formula to the remuneration of judges of the Supreme Court. Yes, I understand what you're trying at. Ivan, first of all, salary of the members of the HQCJ who used to be judges is linked to the remuneration of the judges of the Supreme Court. But those who were not judges, well, their salary is linked to the salary of the High Specialized Court of Ukraine. To tell the truth, I don't know, but it seems to me that this is too high a salary. Okay, I think for a start, it's enough for me. And let me give the floor to my colleague, Robert. Thank you for your answers. Robert, you're welcome.
Thank you, Ivan. I hope you allow me to say Iryna. Otherwise, I have to see Davydovych is possible for me. Davydovych? Yes? In your motivation letter, you describe your motivation to participate in the commission with a reference to the theory of Abraham Maslow. Yes? According to the theory, every human has 5 sets of needs, which come in a particular order. As each level of need is satisfied, the desire to fulfill the next set kicks in. The first levels are the need to have food, drink, sex, to be safe, and to be loved. The 4th stage is about social recognition, status, and respect. And there's also a 5th stage. What stage are you referring to if you refer to this theory? Is it about, for you, social recognition or fulfillment? What is it?
Yeah, fulfillment, the 5th one. This is their desire to self-fulfillment, not social recognition. I think that for social recognition, I've got everything I need. That is the 5th tier.
So you believe that you have sufficient social status, social recognition, social status, and respect from everybody, that you're now there in the 5th stage to be looking for fulfillment? Okay.
Yes, that's what I think.
Okay. You say that it will be difficult for you to comply with the restrictions defined by Article 12 of the Code of Judicial Ethics in your motivation letter. You recall that? You say,
Звичайно.
Yeah, sure, I do remember about this.
you say in particular not to disclose information that become known in connection with being a member of the HQCJ. What you in fact say, if I translate it in my own words, and you have to tell me whether it is correct or not, is that when you are a member of the HQCJ, all the information that you acquire in that position, you will, let's say, discuss with the outside world in whatever way, shape, or form. So you will not keep anything to yourself. And my question is, of course, is this in compliance with the obligations of a member of the HQCJ? Doesn't this, in fact, disqualify you to be a member of the HQCJ?
Я розумію вимоги кодексу
Well, I
суддівської
understand what
етики і
the
розумію,
requirements of the
що
Code of
члени
Judicial Ethics are, and I understand that the HQCJ member is limited in the right to disclose the information he comes to know or she comes to know due to his or her activity. I just mean that it will be difficult personally for me to keep to this rule because I'm used to being open. I'm used to being able to discuss everything which is done within my research and teaching activities. So it will be difficult for me to keep to that. That's the only thing I meant.
більш того, мені
All the more,
дотриматись ще
it will be
одного
difficult for me to keep to one more provision, not to criticize judicial decisions that have come into effect. I can see a lot of mistakes in judicial decisions that have come into effect as a lecturer. And at every class of mine, I try to show this. So it will be difficult for me to restrain from that practice if I'm elected a member of the HQCJ.
Well, you said also I have difficulty to work in a team. Let's say we have a team, our commission, and we have an interview with you. And then I would start discussing with you now what I think about Ivan and about Ted and what we have discussed before when we discussed this interview with you. You do understand that this is impossible, that working in a team with Ivan would be very difficult if I start discussing now with you what I think of him.
Звичайно, я ще раз сказала.
Well, sure, I understand this. I've already mentioned that I realize what the principles are, but you asked me what I will find difficult to comply with, so I've just told you that it will be difficult for me to keep to those principles.
Yeah, but my answer was, does this not disqualify you to be a member of the HQCJ?
Вам вирішувати.
Well, you are to decide.
Okay.
Принципами роботи є
The principles of the work of the HQCJ are openness and transparency, and these are the traits of character that, well, I could comply with, and that they can help to shape up a good opinion about the HQCJ in the civil society. They could be good where you need to arrange cooperation with the Public Integrity Council. That's why every feature has some positive and negative things, and I do realize that there are some disadvantages, but you could also see some advantages. But of course, you are to decide whether I can be a member of the HQCJ or no.
Пані Ірино,
Irina,
коротке запитання.
just a quick question, clarifying question.
Часто критикуєте
You seem to criticize decisions of courts and judges and Supreme Court, including quite often. Why are decisions so bad?
чому причина?
What do you think of this?
Пане Іване, в тому числі,
Well, Ivan, I think that one of the reasons is
Окей.
poor quality selection. I understand that the selection took place for the first time, but probably that's not because of that. I know that some judges of the Supreme Court are the judges who didn't have any judicial experience. I don't want to criticize the decisions, but if the judge of the Supreme Court In the interview to the edition, Davydovych tells that it is possible to have a reconciliation agreement under Article 2 of Article related to traffic rules, traffic regulations 286 that led to the death of the victim. But it's not generally possible according to the law to do this. Yes, but I'm not talking about the interviews, I'm talking about the decisions. I just didn't want to talk about decisions. Yeah, but do not mention persons. Let's not criticize colleagues, of course. Let me criticize the decision. No. I just mean that the main reason, as you think, is that the selection was a poor quality process. Well, not in general poor quality, but there were some problems with selection. Yes.
I've only one other question for you. In your motivation letter, you propose election of judges of first instances by citizens of Ukraine. So you think that judges should be elected, and you also say that those judges should be elected by people residing in the territory covered by the jurisdiction of the respective court. So you say, I think that judges should be elected, and they should be elected by the people who decide how in the area where the court will be active. My question to you is, can you please explain why election of judges would be a good idea, especially in a country where often people who have considerable means are able win cases, and that people in considerable means may support the judge to be elected? Is not the election of judges by the people in the area where the judge will be active, let's say, an invitation for corruption?
Well, I don't think so. Will you give me a chance to answer?
Звичайно, відповідайте.
Yeah, sure. Well, I just thought that there may be some continuation to the question. So I was trying to tell Ivan that this is not the best option, and I do realize this. You use the notion of corruption, and we are talking about the person who has passed through all the previous stages of selection organized by the HQCJ. And actually, the preventive mechanisms have been used. We have selected a person who has passed the initial exam, who has undergone training, who has passed qualification assessment, and who has passed special inspection. So all the preventive mechanisms have been applied. And here comes the fact that you're elected by a person who lives in a certain community. And I think that this creates the feeling that you need to work in the way for these people to be satisfied and not to be withdrawn by those people. A kind of a sense of responsibility. I understand that it's not always everything the honest during the election, but as for me, this is the option that will make the community and the society trust judges they have elected more. I also understand that this is not the best option possible.
Okay, you agree with me, it may be better that first Ukraine perfects its way as a democracy before we start electing judges.
This is really not the best option. I can agree here. And there is a statement that democracy is generally not the best form of management, but no better form has been invented by the mankind. So this is also probably not the best form, but the mankind had not yet devised any better one.
Okay, Mr. Chairman, back to you.
Я зараз передам слово
Let me now give the floor to our colleague Stephen Markman.
Продовження вашої відповіді.
And just a quick comment. It seems to me that Stephen represents the US, and it seems to me that the US is the only country of the world where the election of judges is in place. I don't know any other country where this idea would really operate. Stephen, you're welcome.
Well, thank you for noticing that, Ivan. I appreciate that. Professor Davydovych, thank you very much for participating in this competition. And I do appreciate your creative and innovative thinking, and I think you've got some interesting ideas. And I think that the idea that Judge Mashenko is referring to may be one of those. We do have in each of our 50 states an electoral system. Within our federal system, we have life tenure, so there's no election and there's no term of office. You're speaking about elections with a fixed term. There would be no opportunity for re-election. Is that correct?
Well, first of all, I'm talking about the fixed term, but only in relation to trial court judges, not about the state level, I mean federal level, because I think that the judges of appellate courts and the Supreme Court and the high specialized courts should have a different procedure, and this election procedure should not be valid for them. But for trial courts, judges should be appointed for a fixed term for 5 years. Let it be 5 years.
I'm not sure there's any one of the 50 states in the United States that has a single fixed term. I'm also not sure that there's any state that has life tenure after an election. Most states would have an initial election for a term of office, and there would typically be the opportunity to seek re-election, perhaps up to some retirement age limit. The good aspect of that, in my respective judgment, would be that you do have to mix with the people a great deal. You have to campaign, you have to appear at events, you have to introduce yourself to people, you have to explain what the judicial system is like, you have to explain your own theories of how you decide cases, and you have to compare and contrast yourself to other candidates. So I think it's a pretty good balance of a system. I'm not sure it's perfect because there is controversy about the need to have re-elections for judges. But I think there's some weaknesses in a system in which somebody's also placed on an important court to make important decisions for what might be the rest of their life. That's a problem too with me. So I think you raise an interesting issue, and thank you for doing so. Professor, if members of the high qualifications commission could be urged to read one of your books or one of your research articles on their first day of taking office, is there one that quickly comes to mind that you would encourage them to look at, one that they might find particularly relevant and instructive for the work that they have to do on the High Qualifications Commission?
Well, this could be the publication on the limits of judicial discretion in criminal proceedings. I've got this publication.
I noticed you referenced that one. Explain to me what the subject of that is briefly, because it seems to me that judges, by necessity, have some discretion in the typical criminal justice decision. Certainly that discretion is cabined by the law, which it should be. They're not free agents, free to do whatever they want to, but there's a mix, there's a balance of discretion and obligation under the law. Are there any principles that you would articulate that are derived from that particular article that might be interesting for new members of the commission?
Thank you. Let it put it in brief. I think that you know about Aaron Barak's paper. This is the former judge, the head of the Supreme Court of Israel, and it is related to Ukraine now. We, both at the level of legislative initiative and at the level of the requirement of the civil society, have the requirement to limit discretionary mandate of judges. The judge should act following a certain algorithm. Now, yes, we have the corruption component because of the discretionary powers of the judge. I think that this is actually not right. I think that if the judge still has the discretionary mandates, and these powers, this mandate can be left with the judge because of some requirements concerning individual regulation and because some issues are still not regulated by the law. So the reason for those discretionary powers may be different, but the judge anyway has to administer justice in a high quality way without any pressure. So everything which is within discretionary mandate is legal. And I would like our society to understand this. The role of the judge is not just to be an automatic machine that will pass the decision clearly following the mechanism set out in the law.
Well, we could certainly have a debate and a conference on those issues, many conferences on those issues. I guess I would just ask you whether you don't see there being a tension between the idea of enhancing discretion and obligating the judge to comport with the rule of law. I mean, the rule of law seems to suggest that the judge be constrained at least to some degree, does it not? How do you arrive at the right balance, at the right equilibrium between discretion and obligation under the law, so that we don't have each judge with their own understanding of what's required in the criminal justice system?
Thank you for the question. I think it's difficult to strike the right balance, but that all depends on the issue that is considered by the judge. Suppose we are talking about his mandate when he's selecting a means of punishment. Probably the range of discretionary mandate and powers could be wide because he could take into account the exact individual. But if we are talking about compliance with certain procedures, so in most cases this requires clear regulation, unambiguous regulation. So this balance depends on the issue considered. On the part of the judiciary, a segment where you are exercising your powers.
You know, we've seen the development in the United States over the last 20 or 25 years of sentencing guidelines where judges are actually subject to greater constraints than they used to be, because they look at the crime that's taken place and they look at the history of the criminal, and they have an algorithm, and then that algorithm says under these circumstances you can't sentence from 0 to 20 years in accordance with the law, but you have to sentence to 8 to 10 years in accordance with the guidelines. So what that does is make sure that the most liberal judge doesn't sentence somebody to 2 years and the most conservative judge to 20 years. And it's been generally received pretty well because there's a sense that it's a more fair system. But people can differ on these things, of course.
If you allow me to comment upon this, well, it's not the answer, of course, because there has been no question, just continuation of our discussion. You are talking about the system in which you have high-quality regulatory acts and some regulatory acts and guidelines. But I would rather rely on the legal conscience of the judge and the quality of our legislation now. Sorry, but let me be frank about that.
One final question on that, and then I'll leave you be, but I could talk with you about this all day. Doesn't that transform the rule of law into the rule of judges? Isn't there a distinction between those concepts?
Well, you know, the rule of law is not the rule of legislation. And during our Orange Revolution events in 2004, the Supreme Court of Ukraine, the civil chamber, passed a decision in the situation when the third round of presidential election was actually not envisaged by the law, and it referred to the principle of the rule of law. So it was really strange for me And that's what I would be striving for. But there must be restrictions. I do agree with you in this, definitely.
Well, once again, I appreciate your thinking outside the box, and I appreciate your insight and thoughtfulness on these issues. Thank you.
Thank you. Моє прізвище Мезенцев.
Thank you. So I'm Yevhen Mezentsev, Iryna, and let me also ask you a couple of questions. Let me give you a compliment. You know, it's a pleasure to see a person who is so honest and who is so straightforward as far as her judgments are concerned. And you know, the fact that you claim that it's difficult to you for you to come in contact with the people who don't share your opinion, or that it's rather easier for you to perform a task on your own than to shift the responsibility on somebody else. This is the inner feeling of a lot of people, but not everybody can tell about this. So we're grateful for your frank communication. That is really precious. Let me also tell you concerning the judges, election of judges in Ukraine. It's really true that in the US there is the election system for trial court judges for different periods, and only federal judges are appointed for lifetime for specialized courts, and we will not talk about that now. While being at a training course in the US for 2 weeks, we had some communication with judges concerning election of judges, and you know, not all judges are satisfied with it. Some judges claim that the election campaign costs a lot of money. They need to take this money from somewhere, and most often they borrow this money from the law firms where they used to work, or the lawyers who represent the interests of clients in some areas. And there is a certain conflict of interest concerning involvement of the judge's donors who funded his election campaign in the court settings, and that causes some frustration and conflict of interests, and leads to some recusals of judges. So that is, of course, not an ideal situation. And in the US, well, you claim that the Institute of Election of judges of trial courts could actually lead to improved reputation and trust in the judiciary. Well, maybe it works vice versa. I mean, that high level of trust in judges and the judiciary leads to the fact that judges are elected. So that could be the reverse direction. We need to still think about that. Some questions. You mentioned that you had some conflict or some unpleasant situation with the HQCJ, that your contact was not a success. So could you talk about that? Well, sure. I didn't use the word conflict. Okay, some unpleasant experience, let's call it like that. Yes. So in 2017, I was addressed as a scientist, as a researcher by the representatives of the High Qualification Commission of Judges of Ukraine, and they asked me to develop a practical case for the judges of the Supreme Court for that competition. I agreed to do this, but the time was too short, and I said it was not possible to do this. And I told, what is the problem? We will give you access to the cases of the Supreme Court of Ukraine. You will take all the materials and you will quickly reshape them into the practical assignment. And I answered that that would be a bad job. I would not do this. And I can tell you why this cannot be done if you ask me to. Yes, please. Well, first of all, judges of the Supreme Court could have been acquainted with the decision, and this means that they would have some advantages above others. Also, that decision could be passed within the limits of judicial discretion, and that will also be an obstacle. I mean that we think that the only correct judgment is the one passed by the judge, but in fact there may be two options, let alone that there could also be some judicial mistakes not corrected by anyone.
Перший мій негативний досвід.
This is the first negative story.
Хоча, до речі,
And you know, I
навіть
refused.
серед нашого ректора.
But there was some pressure exerted on me even via our rector. And then in 2018, I was again given a suggestion. So after that failure, they still addressed you. This means that you are a highly reputable person. Well, I don't know what the reason for that was and who actually promoted me for performance of that task among the members of the Scientific and Methodological Council of the National Academy of Judges. I don't know who it was. I refused, but that was because I was trying to be the candidate of the judge of the Supreme Court. And here is all about my experience of writing a practical task. You know what? I did not write it. I cannot explain it to my students. But, well, the case was rather obvious and clear for any expert in criminal law that was the judge of the trial court decision, some wrong rules of substantive law. But the judge of the Supreme Court was supposed to cancel these decisions because there were grounds for that. But then the criminal procedure law allows you to send the case both to trial court and to second instance court for reconsideration. And there is no right choice. I wrote to the trial court. It appears that I was supposed to write to the second instance court. And some of the colleagues who also participated in the selection, even my students who had already worked as appellate courts and even heads or presidents of appellate courts, also tried to have this decision of the HQCJ cancelled. They took some scientific opinions in the Institute of the State of Law named after Koretsky. But, you know, they failed as far as I know. This didn't lead to any result, but I myself was not involved in this. But, you know, I really felt bad about this decision passed by the HQCJ members. It seems to me that they just had the practical task developed and the right answer to it, and nobody gave a look at the fact that actually there were two right answers there. Okay, that may well be true. Irina, here is a personal question concerning your declaration, property declaration. The position of your husband was mentioned. He is the head of the medium size in the Anti-Corruption Bureau of Ukraine. And in your declaration of family taste, you didn't mention this fact, and some of civil society organizations have some concerns and reservations concerning your integrity as the result of that. You are a frank and honest person, so please give us the answer. Was it just a mistake resulting from the fact that you forgot that you have to indicate this, or was it a conscious decision that is grounded on some facts? Well, I have already given the answer to this question. I really wrote this in my motivation letter. The point is that my husband is the head of the department, if I'm not mistaken, of supporting and accompanying IT technologies in the information system. So he is an IT guy. In the legislation of Ukraine, we don't have any exhaustive explanation of the notion of the employee of the law enforcement body. There is a law where there is a list of inexhaustive list of non-enforcement bodies, but the notion of the staff member of the law enforcement bodies is mostly related with direct performance of the functions of order protection. But you know, if my husband was a cleaner in Nabu, should I have indicated that he works in the law enforcement body? I don't think so. I don't know. I'm not a staff member of the National Agency for Corruption Prevention, so I don't know. I tried to find some explanations from an ACP concerning how we should fill out the declaration, but there were no explanations. And you know, my PhD thesis was dedicated to criminal protection of the employees of staff of employees of law enforcement bodies. So I know that there is no notion of this staff member. That's why I didn't indicate it. It was my conscious choice. Okay, so I understand that you did this not due to your subconscious mistake, but because you decided to do it like this. It was your conscious decision, well-grounded decision. Yes, and in fact, I mentioned the position of my husband in two documents, in the declaration and in the questionnaire. And, you know, if I wanted to conceal something, and if I wanted to show in both of the documents, to hide something, I mean, both documents, I could have done this. Okay, it's clear. All the more that your standpoint is absolutely clear. You also mentioned that, as you think, judges of the Supreme Court should have smaller load, and there should be some smaller thresholds of access to criminal instance. You're a specialist in criminal law, so let me ask you, what are the thresholds of access that you would like to install for the cassation criminal court within the Supreme Court? Well, these are cases related to grave crimes and particular grave crimes, which presuppose imprisonment for at least 5 years. And what about other types of cases that would be related to the need to give legal assessment and development of a single legal standpoint in some less important category? Would you think it is possible for the Supreme Court to consider this type of cases? If we speak about typical cases, well, probably the Supreme Court has been dealing at the last stage with giving its conclusions, giving its opinions. Okay, clear, Irina. Please, could you tell me the following? One of the person who gave reference letters to you for this competition was Professor of Kyiv Academy, Mr. Havronyuk. His reference letter is rather short but positive, and it fully characterizes you as a professional, a smart and professional candidate. And since, along with that, Mr. Bakola is also involved in this competition, he is also the candidate. So he is the same status with you as you have. Don't you think that this is a conflict of interest, that the other candidate gives positive assessment of you, positive letter of reference? What is your opinion? In your internal documents, it was written that one candidate can give a letter of reference to the other candidate. But back then, when Mykola Havronyuk was writing a reference letter for me, he had not yet applied. Well, that's a different thing. Okay, it's clear. If he had already applied, there could be a specific conflict. All right, and here is the last ethical issue. Let's assume that you are a member of the HQCJ and you are holding a similar interview with one of the candidates, judicial candidates. It's summer, it's hot. Well, and the person has come in just a short-sleeved shirt, and you can see tattoos. Hands and arms full of tattoos. Do you think that tattoos of judges, well, regardless of the content of those tattoos, are they ethical from the point of view of judicial ethics? From the point of view of the Code of Judicial Ethics, the judge cannot show such conduct that could cause some disrespect to court in particular. And how do tattoos show this disrespect for court? Well, on behalf of the society, I mean, this is the same. This is the same as violation of the moral norms. Yes, but these are just some minor tattoos, some birds and flowers.
Це ж не є підставою для однозначної...
You don't think that this is
Це не
ethical,
є
right?
підставою для
But
однозначної
definitely this is
якогось
not
обмеження
the ground
цієї
for
особи у праві
limiting
бути
this person in the right to be a
суддею, але я
judge.
вважаю, що цей момент,
That's true.
що це
But I think that
може
this
принизити
could
авторитет
somehow
майбутнього судді у суспільстві.
worsen the reputation of court. But this is not the ground for assessing the judge. That's absolutely true. Let's have some continuation of this question concerning prohibition of discrimination, concerning the color of skin. How does it correlate? I mean, discrimination, ban of discrimination on the basis of the skin color and tattoos of the future judge. I think that tattoos are not about color of skin. Why? The skin becomes of a different color. Okay. Anyway, I'm satisfied with our communication. Let me give the floor to our next colleague. Serhiy, you're welcome.
Good afternoon, Irina. Good afternoon. So you are our first candidate who is being honest and frank about both their positive and negative sides. And I'd like to focus on one of those things that you've mentioned. This has to do with your motivation to become a member of HQCJ. So you've informed us that you don't have the skills necessary to work in a team, and you've told us, I will not be quoting, but you're unable to trust people and you like to do things by yourself. So I have a question with regards to this trait of yours. So as a member of HQCJ, you will be part of a collegial body that will make the decisions based on the decisions of all the members. So how do you believe, does this trait of yours that you are lacking this quality, but you will have to work as part of a team, how are you going to feel? Will you need some time to adjust, to get used to it? To be honest, if I disagree with a decision made by other commissioners, by other members of the commission, I will try to convince them that I'm right with my decision. I will try to provide arguments, but should I fail, let be it. This is the factor that I've really give some time thinking about before applying. That's why I'm asking you, is it going to be interfering with your work? Because you are going to be part of a team. Yes, it will be interfering, but I will try to convince the other members of the commission that I'm right. If I fail, so suppose you failed, well, I may fail once, I may fail twice or even 3 times, but I will continue trying. But if I see that I'm not successful, then I will not be able to be part of such an HQCJ. In your opinion, what are the changes that should be introduced should you be appointed as a member of HQCJ in order to check the professional competence? So, what do you think about this? Well, if I may, I have reviewed the internal documents that the previous HQCJ worked with, and I believe that they need updating. I don't think they are wrong, but they need updating. As far as current legislation is concerned, current regulations, if we don't have the head, then it's the judge that is appointed by the quota of the Congress of Judges. But this is already an outdated provision. So we can also update the approaches, paying attention to the current situation. I believe when setting the criteria of integrity, compliance with the integrity criteria, I would add to the existing methodology. I would also analyze availability of family ties with a citizen of Russian Federation, crossing of the border with Russian Federation or Belarus, a person having property in Russian Federation. So I believe that these things should be added. As far as professional competence criteria is concerned, you may remember that one of the aspects is checking the level of the ability of a judge to compose a court decision, a court judgment, as far as I remember the wording. How is it checked? According to current methodology, it's checked during the performance of a practical assignment, which is part of qualification assessment. And I would suggest something different. I would request that the decisions of the judge be reviewed, previous decisions of the judge, if we are not talking about candidate judge, without even going very deep into those decisions. We can check whether they have the necessary structure, the introductory part, the body, the conclusions, where they are motivated enough. As a specialist in criminal law, if I saw a court decision which did not have enough motivation for the punishment, and the judge just copied some of the provisions from the criminal code, I would already see that the decision was not motivated enough. So review of the previous decisions of a judge, review of court hearings where that judge presided, and it's quite possible in many cases to do that. So I think this element should be included into the qualification assessment so that we can make better conclusions about professional competence of a specific judge. That's quite clear. Thank you, Irina. I'm passing the floor to Ted Zazhechny. Ted, you're welcome.
Thank you, Judge Verlanov. It does not surprise me, Professor Davydovych, that an academic with your experience and years of work has some significant ideas about reforms that you have shared, some of which you have shared with us. I think it is quite typical for academics to be the source of, if you like, activism with respect to changes that are seen either to be recommended or appropriate to the judicial system, to use this example. However, and therefore I would compliment you by identifying you in part as a reformist. The concern that raises for me, however, is that the High Qualification Commission of Judges has an enormous workload ahead of it in the next 4 years. And it is an establishment organization. It has very little time to entertain the kinds and extents of reforms that you appear to be very interested in. Their work is very much work on the ground. They have, as you are very well aware, I'm sure, over 2,000 judges that require requalification. There are over 2,200 judge positions vacant. And so it is a heavy workload, and there's not very much time, it seems to me, for thinking about or inventing changes. So how do you reconcile your very extensive interest in some very, very dramatic reforms on the one hand, and performing the work of an institution like the High Qualification Commission that will have very little time to entertain such ideas because there is so much work to be done based upon the existing structure. So I'd be interested in your views on that.
Thank you. I do understand that the work of an HQCJ member is not a work on implementing reforms. You asked me about my opinions of the reforms in the motivational letter, and I've expressed my views, but it doesn't mean that I'm going to implement them as a member of HQCJ. It's probably impossible. I'm not going to be talking about lack of legislative initiative that HQCJ and HCJ have. Yes, we can write some academic papers, we can write some petitions to the Verkhovna Rada, but this is not legislative initiative. I was just expressing my vision, my view of the necessary reforms so that we can restore the trust of the people in the judiciary. I can work hard, I can work a lot, I can work extra hours, and I will not be asking for extra payment for that. Believe me that the workload that we are currently having as professors is quite big. On Monday, I was the official opponent during presentation of one PhD thesis, and for tomorrow, I already need to prepare a review for another PhD thesis, and this is a difficult job to do. I know how to work hard. I'm not afraid of it. Can I add something?
Yes, of course.
Where my experience may be of relevance in the development of tests and practical assignments. I think that the High Qualification Commission is responsible for the content of these tests and assignments, and I will be ready to check them. So I believe that I can use my theoretical background so that we have fewer mistakes. I already have some ideas about the development of the regulations of HQCJ internal methodologies for the assessment. I have vast experience in developing different exams, entry exams, graduation exams, qualification exams for master's or bachelor's program students, current exams. So this is my normal mode of work. I don't see this as being too difficult.
Yes, thank you for your answer and that additional information. Have you ever volunteered to participate in the work of the National School of Judges, and have you presented any courses or programs of education for judge candidates?
No, I've never worked with the National School of Judges, other than the case when I was approached to design some tests. But the courses that I deliver at the university are quite useful. I believe they would be quite useful for judges because it deals with the use of judiciary, with the use of criminal punishment in the judiciary.
You know, I find it somewhat curious, I must say. You advocate for the principle of the election of judges on the one hand, and on the other hand, you are applying to be a member of the High Qualification Commission, which reviews judges to be appointed, not to be elected, but to be appointed. So do you find that to be somewhat a conflict?
No, I don't find this to be a conflict. I advocate for the election of a judge after a candidate judge has completed all the stages of assessment that are currently outlined by HQCJ, and when they are already in the reserve, it's not the HQCJ selecting, but the people electing amongst those in the reserve. I don't see any conflict in here. I believe that the existing procedures are all relevant. The selection exam, the special training, the special inspection, and the qualification assessment.
My last question is a concern that your candid sharing with us raises, and that is that you have very little experience in working as a member of a team, and you even go farther and say you're not sure that you're interested in working as a member of a team because you like to work alone. Now, the work of the High Qualification Commission, indeed even by its own laws and regulations, requires teamwork. In fact, it is essential to the successful operation of the High Qualification Commission of Judges. You work in panels, you interview people in panels, you discuss with your colleagues the results of your analysis and assessments, et cetera, and as you've quite rightly recognized, you have a responsibility to attempt.
Yes, of course, I do realize this, but you must understand that the presentation of PhD thesis, for example, and I'm a member of a specialized scholarly council. I'm also a member of the panel of examinators. I'm not saying that I'm incapable of working in the team. I'm talking about problems in day-to-day work, for instance, interaction with the inspectors. I'm not afraid about assessing or discussing candidates post their interviews. Here, I do have the experience.
All right, thank you. I will pass you on now back to the chairman. Thank you.
Thank you for the answers, Iryna. Dear colleagues, do we have any more questions for our candidate? Iryna, the Commission is giving you the floor towards the end of your interview for some concluding remarks. Suppose you'd like to add something or you'd like to draw our attention to some additional facts, so what would you like to tell us towards the end of this interview? Thank you, Ivan. So let me add about the cooperation between HQCJ and PIC. I believe that the provisions currently outlined in the law and in the regulations for HQCJ should be reviewed. What was the problem about? The opinion of PIC members was ignored because we have 11 members of HQCJ that can overcome any opinion expressed by them. So apparently this issue should be solved in a different manner. Maybe there should be an unofficial agreement, maybe this should be reflected in the regulations, that the members of PIC do not interfere with the issues of professional competence, because they don't motivate lack of professional competence by the judge making a bad decision. They can only assess the integrity and compliance with the requirements of ethics. But on the other hand, when HQCJ members overcome the negative opinion, they should always motivate such a decision. We can go even further and introduce something like the selection of a judge of High Anti-Corruption Court were the joint meeting of HQCJ and the international experts together make the decision on whether the judge complies with the requirements or not, and the position of the international experts is taken into account. I believe that this is important to mention, but of course this would require amendment of the legislation. We cannot invite all the members of PIC because we have 20 people there and we have less people on HQCJ. And towards the end, I would like to say that I do realize the workload that you are currently having. I'm indeed impressed by the time that you are affording to us and the volume of work that you have done in preparation for this competition. Even though I do see some faults, I wish you to choose the best. And another wish, don't consider this to be interference with your work, but please take into account the specialization of these candidates who will be appointed to HQCJ. I would like to see specialists in civil law, in criminal law, so that the HQCJ can assess the tests, because there are some faults in the tests, the practical assignment. I want for these people to be responsible for their work. I would like to have people on HQCJ who can assess previous decisions made by judges by looking at the copies of such decisions. So that is something that I believe you should pay attention to. Thank you.
Дуже вам дякую, пані Ірино.
Thanks a lot, Irina. Thank you for your warm wishes.
Співбесіда завершена. Всього
This is the end of your interview. We wish the best of luck to you. Take care. Goodbye. Goodbye.